Chapter 17 Land Use Regulations Introduction. Objectives. In this chapter, we will discuss both public and private land use regulations. At the end of this chapter, you will be able to 1. Describe the significant forms of private and state environmental land use control including deed restrictions, covenants, and the SEQR. 2. Define and describe salient forms of public land use control including sale disclosures, taxation, eminent domain, building codes and permits. 3. Describe the classifications of zoning and the various land use restrictions imposed by each zoning type. 4. Identify the principal activities that comprise municipal planning and management including master plan development and key zoning actions such as moratoria, housing development approvals, and zoning appeals. Key terms. There are a number of important terms in this chapter. Remember to pay particular attention to these terms when you see them. Abutting. Lead agency. Accessory apartment. Master plan. Accessory uses. Moratorium. Building code. New York State Office of Parks, Recreation and Historic Preservation. Building permit. Non-conforming use. Census tract. Police power. CO certificate of occupancy. Restrictive covenant. Condemnation. Setbacks. Cul-de-sac. Spot zoning. Deed restriction. Subdivision regulations. Demography. Survey. Doctrine of laches. Taking. Eminent domain. Topography. Escheat. Transfer of development rights. Family. Variance area variance use variance. Group home. Zoning ordinance. Home occupation. Infrastructure. The New York Bureau of Educational Standards requires that you spend 150 minutes studying the material in this chapter. Your course timer can be found in the upper right-hand corner of your screen. Bundle of rights and as of right zoning. As we discussed in an earlier chapter, when someone owns a parcel of real estate, he or she also has a set of legal rights that are attached to the ownership of that parcel. These rights, which have value and can be sold, are known as the bundle of rights. Implied in that bundle of rights is the principle of as of right zoning or as of right use. This term refers to those uses that are automatically allowed by the zoning code. They are allowed as a matter of right. Certain structures and land uses pose little threat to the communities in which they're built. In many areas, those structures are defined in the zoning code and can be built and occupied without public hearings, debates, or special approvals. For example, in a residential area of single-family homes, a contractor who owns a lot can build a single-family home without having to get special permission. It is an as-of-right use of that lot. Or if the zoning code says that 1, 2, or 3-story homes are allowed in any residential zone, then any property owner can build a 1, 2, or 3-story home in that zone. The need for future planning. Even though owners enjoy the complete bundle of rights attached to their property, local governments still have a stake in property that is privately owned. The government is charged with the responsibility of making sure that owners do not use their property in a way that will harm the public. For example, an owner cannot use his or her land in a way that would pollute the air or water quality of the surrounding area. Or an owner cannot use his or her property in a way that might decrease the value of other property in the area, such as by opening and operating an industrial enterprise in a residential neighborhood. Over time, the control of land use has come to focus on certain core purposes. These are: preservation of property values, promotion of the highest and best use of property, balance between individual property rights and the public good, that is, its health, safety, and welfare, control of growth to remain within infrastructure capabilities, incorporation of community consensus into regulatory and planning activities. The most favorable management of real property usage must take into account both the interests of the individual and the interests of the surrounding community. Historical development of land control. Private control of land use was the precursor to public land use control. In 1848, courts in the United States recognized and enforced restrictive covenants to regulate land use in residential subdivisions. But it was not until 1926 that public land use controls become legally reliable, when the Supreme Court upheld the validity of zoning ordinances. Before these two important legal events, a developer or government unit had no way to regulate land use, even though it was obvious that controls were sorely needed. The increase in population density has also increased the need for land use controls. Abuse by even one landowner in how he or she uses his or her property can have a substantial undesirable effect on the rights of other property owners and cause significant depreciation of their properties. Private land use control. Individual owners have the right to put private controls on their own property. The controls could be in the form of liens or easements, as we discussed in an earlier chapter. Or they can take the form of individual deed restrictions or private subdivision regulations that affect the entire subdivision. Deed restrictions. Individual deed restrictions place limits on how the property may be used. Restrictions are also known as covenants, conditions and restrictions, or CCRs. A covenant may be included in a deed to benefit a property that is sold or to benefit a property that is kept when an adjoining property is sold. For example, an owner who retains one property and sells an adjoining property may provide in the deed that a structure may not be built in a certain area of the property being sold, to protect the view from the retained property or to prevent loss of passage of light and air to the retained property. These restrictions are covenants that run with the land, that is, they move with the title in any subsequent transfer. Covenants may be enforced by a suit for damages or by injunction. Restrictions that provide for a reversion of title if they are violated are called conditions. If a condition is violated, ownership reverts to the grantor. These conditions create a defeasible fee estate which, as you recall, we discussed in an earlier chapter. Restrictive covenants. Restrictive covenants are limitations placed on the use of land by the developer of a residential subdivision. The purpose of these covenants is to preserve and protect the quality of land in subdivisions and to maximize land values by requiring the homogeneous use of the land by purchasers. The covenants are promises by those who purchase property in the subdivision to limit the use of their property to comply with the requirements of the restrictive covenants. Therefore, they are negative easements. The deed conveying title to the property in the subdivision contains a reference to a recorded plat of the subdivision and a reference to recording of the restrictive covenants, or the restrictions may be recited in each deed of conveyance. Restrictions must be reasonable, and they must benefit all property owners alike. If the subdivision is in a zoned area, restrictive covenants have priority over the zoning ordinance to the extent that the covenants are more restrictive than the zoning requirements. For example, if zoning says that multifamily homes are allowed but the restrictive covenants prohibit multifamily dwellings, the restrictive covenants take precedence and will be enforced. However, the restrictive covenants will not be enforced if they go against public law or policy. For example, restrictions may not be discriminatory by restricting ownership or use on the basis of race, religion, marital status, or gender. Restrictions on commercial property use may not violate fair trade and antitrust laws. Typical restrictions. Here are some restrictions you might see in a subdivision declaration of restrictions. Only single-family homes are allowed. Homes must have a specified minimum number of square feet of living area. Only one home is allowed per lot. Lots may not be subdivided. Homes must be architecturally similar. All site plans and structure specifications must be approved by a committee before construction. Buildings must be set back a certain number of feet from the front property line and from the interior property lines. No temporary buildings are permitted. Either one property owner or several owners can initiate a court action to enforce the covenants. Covenants are in effect for a certain period of time. Some restrictions are automatically renewed, but can be changed by a vote of the property owners. Enforcement. As we mentioned above, the property owners can enforce the covenants by taking a court action known as an injunction. An injunction prevents the owner or owners from using a property in a way that is contrary to the recorded restrictions. It can also order the removal of a use that has already been implemented. So, it falls to the owners of the property to make sure that the other property owners are complying with the restrictions. This responsibility passes to any new owners who may purchase property from the original owners. Terminating covenants. Restrictive covenants may be terminated in any of these ways. The specified time period of the covenant expires. The property owners vote to end the restrictions. This may require a unanimous vote of all owners or a smaller vote of some subset of owners, depending on how the restriction was written. Over time, the character of the subdivision changes, making it more suitable for some other kind of use. The property owners choose not to follow the original plan by violating their own restrictions. In this kind of situation, any attempt to later enforce the restrictions might be disallowed by a court. The owners do not enforce the restrictions in a timely manner. For example, if the property owners wait until an inappropriate structure is complete before they petition the court for enforcement, the court may choose not to enforce the restriction and terminate it altogether. When a court terminates a covenant in this way, the court is applying the doctrine of laches. This doctrine states that if a property owner is lax in protecting his or her rights, the property owner may lose those rights. State Environmental Quality Review. New York State Environmental Quality Review Act requires all state and local government agencies to assess the environmental significance of all actions they have discretion to approve, fund or directly undertake. SEQR requires the agencies to balance the environmental impacts with social and economic factors when deciding to approve or undertake an action. Some examples of actions which fall under this act include the approval of or development of shopping centers, factories and office buildings, residential developments, public buildings, mines, roads and landfills, work in streams and other water bodies, work in wetlands, construction of dams to hold back water. If an action is determined to have possible significant adverse environmental impacts, an environmental impact statement is required. The agency that oversees a project and makes the final decisions is called the lead agency. An EIS succinctly explains and analyzes a proposed action which may have a major impact on the environment. The EIS is available to the public for information and comment. An EIS must include description of the action, including its need and benefits, description of the environmental setting and areas that would be affected, an analysis of all environmental impacts related to the action, an analysis of realistic alternatives to the action, identification of ways to decrease or avoid undesirable environmental impacts. State Environmental Quality Review. There are some actions that are listed in the statewide and agency SEQR regulations which have been determined not to have a significant adverse impact on the environment. These are called Type 2 actions. Some examples of Type 2 actions include rebuilding or replacement of facilities, in kind, on the same site. Minor structures, such as garages, barns or home swimming pools. Routine permit and license renewals with no substantial change in permitted activities. Construction or expansion of either primary or accessory non-residential structures in an appropriate zone with less than 4,000 square feet of gross floor space. Construction or expansion of a single, 2 or 3 family residence on an approved lot. Routine activities of educational institutions, including expansions of existing facilities by less than 10,000 square feet. Maintenance and repair activities. Emergency actions. Actions of the New York State Legislature and the Governor. SEQR is of benefit to the public, agencies, and project sponsors. The public may Participate in scoping the draft Is. Review SEQR documents and provide comments to agency decision makers. Participate in SEQR hearings on the environmental impacts of the project. Check your understanding. Print this screen, answer the questions and then advance to the next screen to see the answers. 1. Define as of right zoning. 2. What do deed restrictions do? 3. What is the doctrine of laches? 4. What does New York State Environmental Quality Review Act require? Check your understanding. Answers 1. Define as of right zoning. This term refers to those uses that are automatically allowed by the zoning code. They are allowed as a matter of right. 2. What do deed restrictions do? Deed restrictions place limits on how the property may be used. 3. What is the doctrine of laches? This doctrine states that if a property owner is lax in protecting his or her rights, the property owner may lose those rights. 4. What does New York State Environmental Quality Review Act require? New York State Environmental Quality Review Act requires all state and local government agencies to assess the environmental significance of all actions they have discretion to approve, fund or directly undertake. Public land use controls. The private land use controls we have discussed on the previous screens are limited in their scope. Only small, specific areas are subject to private use controls. Public land use controls are much broader, encompassing much larger areas of land. Police power gives a government entity the ability to fulfill its responsibility to provide for the health, safety, and welfare of the public. The exercise of this power must always be in the best interest of the public. However, the exercise of this power may restrict some of the fundamental freedoms of the people. Some examples of the exercise of police power include zoning ordinances, building codes, subdivision regulations, eminent domain, environmental restrictions. Property owners who are affected by the exercise of police power are often not compensated for the imposed restrictions and loss of use of their property that can result from the exercise of this power. It is always believed that if restrictions are imposed, they are for the health, safety, and welfare of the public. Interstate Land Sales Full Disclosure Act. The Interstate Land Sales Full Disclosure Act is a federal law that regulates the interstate sale of unimproved lots. This act is administered by the Department of Housing and Urban Development. The purpose of this act is to prevent fraud in marketing land that can be sold sight unseen. Developers must file a statement of record with HUD before they can offer any unimproved lots for sale by telephone or through the mail. HUD specifies what kind of information must be disclosed in the statement of record. Developers must also provide a buyer or lessee with a printed property report, which gives specific information about the property, before the buyer or lessee signs a purchase contract or lease. Some of the required information includes the type of title the buyer will receive, availability of recreational facilities, distance to nearby communities, utility services and charges, soil problems. If the developer does not provide the property report before the buyer or lessee signs a contract, there will most likely be grounds for the contract to be voided. Exemptions to this act include subdivisions with lots of 5 or more acres each, subdivisions with less than 25 lots, lots offered exclusively to building contractors, lots on which there is an existing building, lots that have a contract requiring the lot seller to erect a building within 2 years. The Act provides for harsh penalties for violation by a developer or a real estate licensee who helps in marketing the property. Before getting involved in marketing such properties, licensees should make certain the developer has followed the requirements or is exempt from them. New York State Article 9A. New York State Article 9 requires a subdivider to make a filing with the New York State Department of State before offering to sell or lease subdivided vacant lands to New York State residents on an installment plan. This filing is required regardless of where the subdivided lands are located and where the offer is made. In other words, the property can be located outside of New York State. There are two important points to note here, and both points must apply. First, this law applies only to vacant land. It does not apply to lots on which homes have been built. Second, the land must be offered for sale on an installment plan. An installment plan means an agreement to make periodic payments before title is transferred. An installment plan exists if a purchaser or lessee must make at least 2 installment payments before receiving a deed or lease. Deed and mortgage transactions which require a down payment or multiple down payments are not included in this definition. Since deed and mortgage transactions are the most common method of real estate transfers, most real estate offerings are not required to be filed with the Department of State. However, when the law does apply, it covers sales made by a salesperson, a broker, or an owner. When the law applies, the subdivider must submit a filing statement and an offering statement accompanied by a fee. Any advertisements about the property must state that an offering statement has been filed with the New York State Department of State, that a copy of such statement is available upon request from the subdivider, and that the filing of a filing statement and an offering statement does not constitute approval of the sale or lease or offer for sale or lease of subdivided lands by the Department of State. Other government controls. Taxation. As we discussed in an earlier chapter, property taxes are a specific lien on the property. The exercise of this power is an inherent encumbrance on the private ownership of property. In New York, property tax liens take priority over any other liens. Property which is owned by the government, a government agency, or a non-profit association is exempt from the payment of property taxes. Another form of control through taxation results when special assessments are put in place to enable areas or neighborhoods to pay for particular improvements. These assessments are not permanent. They typically run for just a few years. For example, a particular neighborhood might be subject to a special assessment to help pay for the installation of sidewalks or street lamps. SEQR. You also remember from an earlier chapter that if a property owner dies with a valid will in place, the property will be distributed as the will specifies. And if the property owner dies without a valid will, the property will be dispersed to the heirs according to the laws of the state and based on the relationship of those heirs to the deceased. If a person dies with no heirs and no one qualified to receive the property, the state will use the power of SEQR to claim the property. By definition, SEQR means that if someone dies with no will and no heirs, all property belonging to the deceased person goes to the state. Other government controls. Eminent domain. Eminent domain allows a government entity to purchase a fee, leasehold, or easement interest in privately owned real property for the public good and for public use, regardless of the owner's desire to sell or otherwise transfer any interest. In exchange for the interest, the government must pay the owner just compensation. To acquire a property, the public entity initiates a condemnation suit. Transfer of title extinguishes all existing leases, liens, and other encumbrances on the property. Tenants affected by the condemnation sale may or may not receive compensation, depending on the terms of their agreement with the landlord. Public entities that have the power of eminent domain include all levels of government, school districts, public utilities, public service corporations, public housing and redevelopment agencies, railroads. To acquire a property, the public entity must first adopt a formal resolution to acquire the property, variously called a resolution of necessity. The resolution must be adopted at a formal hearing where the owner may voice an opinion. Once adopted, the government agency may begin a condemnation suit in court. Afterward, the property is purchased and the title is transferred in exchange for just compensation. Transfer of title extinguishes all existing leases, liens, and other encumbrances on the property. Eminent domain. In order to proceed with condemnation, the government agency must demonstrate that the project is necessary. The property is necessary for the project. The location offers the greatest public benefit with the least detriment. Since an eminent domain proceeding is usually an involuntary acquisition, the condemnation proceeding must be in harmony with due process of law to ensure that it does not violate individual property rights. In addition, the public entity must justify its use of eminent domain in court by demonstrating the validity of the intended public use and the resulting public good or public purpose that will be served. Taking. A taking refers to the taking clause of the Fifth Amendment, which says, in part, that private property cannot be taken for public use without just compensation. If a property owner's right to develop his or her land is restricted by government controls to the point where the land becomes basically useless, the courts could find that the taking was illegal and order compensation be paid to the property owner. Eminent domain. The issue of eminent domain versus individual property rights has come under scrutiny in light of a 2005 Supreme Court ruling that affirmed the rights of state and local governments to use the power of eminent domain for urban redevelopment and revitalization. In this case, the Supreme Court confirmed the right of the City of New London, Connecticut to condemn the homes of private citizens so that the land could be used by a private developer. The justification given was that the development would contribute to the city's well-being. This landmark ruling allowed that private parties could undertake a project for profit without any public guarantee that the project would be satisfactorily completed. The ruling brought the issue of public use into question, since the use of the redevelopment could well be private and even a private for-profit endeavor. The winning argument was that the public purpose is served when redevelopment creates much-needed jobs in a depressed urban area. As a result of this decision, many people see the power of eminent domain and the definition of public good as being in conflict with the constitutional rights of private property ownership. Over time, we may see new and different interpretations of the public's right to preempt private property ownership by eminent domain. Building codes. Building codes allow the county and municipality to protect the public against the hazards of unregulated construction. Building codes establish standards for virtually every aspect of a construction project, including off-site improvements such as streets, curbs, gutters, drainage systems, and on-site improvements such as the building itself. Building codes typically address architectural and engineering standards, construction materials standards, building support systems such as life safety, electrical, mechanical, and utility systems. NYS Uniform Fire Prevention and Building Codes Regulations. This New York code is part of a national fire prevention and building code system. A state may not make changes to the national code, but states can put their own code in place, and that code can be more restrictive than the national code. New York provides minimum standards for all residential and commercial buildings in the state. If a local code happens to be more restrictive, the local code will take precedence. If a local government does not have its own code, then the New York code applies. The New York code deals with construction, safety standards, materials and sanitary conditions in a building. Building permits. In New York, the building code is enforced by building departments that oversee either large cities or smaller communities. The building departments enforce the code restrictions and require contractors to be licensed and insured. Building permit. New York requires that an owner, contractor, or developer obtain a building permit, which gives permission for the construction or renovation of a building or improvement. Building permits are required for both residential and commercial properties. A building permit must be obtained before the project starts, which makes it easy for the building department to monitor the compliance to the local building codes. Local inspectors will conduct frequent inspections of the project during construction. Some projects do not require a building permit. Those projects that are typically exempt from the permit requirement are those repair projects that don't materially affect the structural features of the property. The state code has several exemptions which may or may not exist at the local level, so it's wise for the owner to check with the local building department before attempting any renovations. Any violation of the building codes, however unintentional, could render the title unmarketable. Certificate of occupancy. After completion, building inspectors inspect a new development or improvement for code compliance. If the work complies, the municipality or county issues a certificate of occupancy, which officially clears the property for occupation and use. Check your understanding. Print this screen, answer the questions and then advance to the next screen to see the answers. 1. What does the Interstate Land Sales Full Disclosure Act say that developers must give to potential purchasers and lessees? 2. What does New York State Article 9 require of subdividers? 3. What does eminent domain allow a government to do? 4. What do building codes address? Check your understanding. Answers 1. What does the Interstate Land Sales Full Disclosure Act say that developers must give to potential buyers and lessees? Developers must provide a buyer or lessee with a printed property report, which gives specific information about the property, before the buyer or lessee signs a purchase contract or lease. 2. What does New York State Article 9 require of subdividers? New York State Article 9 requires a subdivider to make a filing with the New York State Department of State before offering to sell or lease subdivided vacant lands to New York State residents on an installment plan. 3. What does eminent domain allow a government to do? Eminent domain allows a government entity to purchase a fee, leasehold, or easement interest in privately owned real property for the public good and for public use, regardless of the owner's desire to sell or otherwise transfer any interest. In exchange for the interest, the government must pay the owner just compensation. 4. What do building codes address? Building codes address architectural and engineering standards, construction materials standards, building support systems such as life safety, electrical, mechanical, and utility systems, local authority. Although the state exercises control over certain public lands in New York, most of the control of land use is exercised by local governments and their planning boards. Zoning is the primary tool by which cities and counties regulate land use. The Zoning Ordinance. The vehicle for zoning a city or county is the Zoning Ordinance, a regulation enacted by the local government. The intent of zoning ordinances is to specify land usage for every parcel within the jurisdiction. In some areas, state laws permit zoning ordinances to apply to areas immediately beyond the legal boundaries of the city or county. Zoning ordinances implement the master plan by regulating density, land use intensity, aesthetics, and highest and best use. Ordinances typically address the nature of land use, office, commercial, residential, etc. Size and configuration of a building site, including setbacks, sidewalk requirements, parking requirements, and access. Site development procedures. Construction and design methods and materials, including height restrictions, building to site area ratios, and architectural styles. Use of space within the building. Signage. Zoning classifications. One of the primary applications of zoning power is the separation of residential properties from commercial and industrial uses. Proper design of land use in this manner preserves the aesthetics and value of neighborhoods and promotes the success of commercial enterprises through intelligently located zones. Common types of zone classifications are residential, commercial, industrial, vacant, agricultural, public open space, parklands, recreational, institutional. Let's look at each of these types more closely. Residential zones. Residential zoning restricts land use to private, non-commercial dwellings. Subzones in this category further stipulate the types of residences allowed, whether single-family, multi-unit complexes, condominiums, publicly subsidized housing, or other form of housing. Residential zoning regulates density, by limiting the number and size of dwelling units and lots in an area. Values and aesthetics, by limiting the type of residences allowed. Some areas adopt buffer zones to separate residential areas from commercial and industrial zones. Residential zoning allows for accessory uses of property. An accessory use is secondary to the main use of the property. A storage shed on a property would be an accessory use. Residential zoning also allows for an accessory apartment. This could be a father-in-law or mother-in-law unit in a residence. Residential zoning also allows for small business owners to conduct business from a residence. Only the property's residents could conduct this home occupation, and the business must be a secondary use of the residence. Any home occupation would be subject to the local ordinances. Residential zones. In the recent past, there has been some effort to allow former residents of institutions to live in large homes located in residential areas. These group homes are typically facilities for 6 or less adults or children who have chronic disabilities. The group home is usually staffed around the clock with trained caregivers. Other facilities that may fit into this category include halfway houses and residential rehabilitation centers. In some areas, residents have resisted or opposed having group homes in their neighborhoods, saying that only a family can live in a residential dwelling. New York defines a family as one of the following: persons related by blood, marriage or adoption living together in one home. Up to 3 persons who are not married or related by blood or adoption living together in one home. Other zones. Commercial. Commercial zones include restaurants, stores, hotels, motels, service businesses and the like. Commercial zoning controls the location of office and retail land usage. Some commercial zones allow combinations of office and retail uses on a single site. Subzones in this category may limit the type of retail or office activity permitted, for example, a department store versus a strip center. Commercial zoning regulates intensity of usage by limiting the area of store or office per site area. Intensity regulation is further achieved by minimum parking requirements, setbacks, and building height restrictions. Industrial. Industrial zones are made up of manufacturing companies and warehouses. Industrial zoning regulates intensity of usage, type of industrial activity, environmental consequences. A municipality may not allow some industrial zones, such as heavy industrial, at all. The industrial park is a relatively recent concept in industrial zoning. Vacant land. Vacant land has no buildings or improvements. It is also referred to as unimproved property. Agricultural. Agricultural zoning restricts land used to farming, ranching, and other agricultural enterprises. Other zones. Public open space. This is space that is not developed for a particular residential, commercial, industrial, or institutional use. Open space can be owned by the government or by private persons. Included in the definition of open space are forestland, agricultural property, public parks, lakes, bays and undeveloped shorelines. Parklands. These may be areas of recreation for the public. These parklands may be monitored by government agencies and preserved for their ecological and educational value. Recreational. Recreational areas in New York are supervised by the NYS Department of Environmental Conservation and the NYS Office of Parks, Recreation and Historic Preservation. Areas falling under this category include parks, shorelines, public fishing access areas, trails, and access to waterways. Institutional. Institutional areas include hospitals, prisons, courthouses, colleges and public schools. Hospitals and public schools may be allowed in residential zones as well if the local ordinance permits it. Other zoning issues. Incentive zoning. Incentive zoning can help to advance a community's physical, cultural, and social goals by allowing land developers to provide specific amenities and benefits in exchange for zoning incentives, such as density bonuses. Density bonuses allow developers to build more units than would normally be allowed in a zoning district in exchange for preserving and enhancing chosen resources or providing other public benefits. Communities have successfully used density bonuses as incentives for protecting important open spaces and for providing affordable housing. Other incentives commonly offered to developers are adjustments to height restrictions or modifications of the floor-to-area ratio of a building. The local government may grant these zoning incentives. For example, if a developer would agree to provide an amenity such as a daycare center, a covered tunnel, or some other desirable service in the building. Other zoning issues. Cluster zoning. Cluster zoning is a type of zoning in which density is determined for an entire area, rather than on a lot-by-lot basis. Within the cluster zone, the developer has greater flexibility in designing and placing structures so long as the overall density requirement is met. The developer may choose to put different types of housing closer together. Those parcels of property that share a common border are called abutting land. Developments in cluster zoning often incorporate open, common areas with park-like settings. The open space might include a swimming pool or bike paths. Sunshine law. Sunshine laws, also known as open meeting law, mandate that meetings of governmental agencies and departments be open to the public. These laws require administrative agencies to do their work in public, and as a result, the process is sometimes called government in the sunshine. A law that requires open meetings generally specifies the instances when a meeting can be closed to the public and mandates that certain procedures be followed before a particular meeting is closed. The Freedom of Information Act requires agencies to share information they have obtained with the public. Sunshine laws apply to regular meetings of zoning and planning boards and special sessions held by local zoning authorities. Transfer of development rights. Transfer of development rights refers to a method for protecting land by transferring the rights to develop from one area and giving them to another. As we have discussed previously, property ownership can be described as a bundle of individual rights, pertaining to things such as minerals, timber, agriculture, riparian rights, surface and groundwater, air, and development. Use of these rights is not absolute. Governmental entities do have the right to limit, to a certain extent, a property owner's use of these rights, and thus the economic value that the property owner can derive from the property. The most commonly used restraint has been on the exercise of the individual's use of development rights, mainly through zoning. The concept of TDRs allows for financial compensation to property owners, while society imposes land use regulations to control growth and development. This approach involves dissolving the right to develop an area that the public wishes to preserve in low density or open space, and transferring those rights to another site where higher than normal density would be tolerated and desirable. The development right is independent of land ownership. The development right becomes a separate article of private property and can be shifted from one area to another and can have economic value. Transfer of development rights. TDR makes it possible for there to be a free exchange of development rights without having to buy or sell land. The downzoning a government entity may enforce on a sending area does not necessarily lessen the economic value of the property within that area, because the development rights remain in the landowner's hands and can be used on other properties of the owner or sold to others for use elsewhere. The most common TDR program allows a landowner to sell the development rights to a developer who then uses those development rights to increase the density of houses on another piece of property at another location. The transfer of development rights is not a new concept. TDRs have been used in some areas of the country for the preservation or protection of open space, natural resources, farmland, and urban areas of historical importance. TDRs also have been used to secure land for solid waste facilities and for the protection of golf courses. More than 20 states have enacted or amended statutes accommodating the TDR concept. Currently, several states have TDR statutes specific to farmland protection. New York has used TDRs to preserve landmarks and to encourage construction of moderate-income and low-income housing. Check your understanding. Print this screen, answer the questions and then advance to the next screen to see the answers. 1. List 4 common zoning classifications. 2. Who supervises recreational areas in New York? 3. What is cluster zoning and what is its benefit? 4. What does the term transfer of development rights mean and how has New York used TDRs? Check your understanding. Answers 1. List 4 common zoning classifications. Residential, commercial, industrial, agricultural. 2. Who supervises recreational areas in New York? The NYS Office of Parks, Recreation and Historic Preservation. 3. What is cluster zoning and what is its benefit? Cluster zoning is a type of zoning in which density is determined for an entire area, rather than on a lot-by-lot basis. Within the cluster zone, the developer has greater flexibility in designing and placing structures so long as the overall density requirement is met. 4. What does the term transfer of development rights mean and how has New York used TDRs? Transfer of development rights refers to a method for protecting land by transferring the rights to develop from one area and giving them to another. New York has used TDRs to preserve landmarks and to encourage construction of moderate-income and low-income housing. The Planning Board. The optimum management of real property usage must take into account both the interests of the individual and the interests of the surrounding community. While maintaining the value of an individual estate is important, the owner of an estate must realize that unregulated use and development can jeopardize the value not only of the owner's estate but of neighboring properties. Similarly, the community must keep in mind the effect of government actions on individual property values, since local government is largely supported by taxes based on the value of property. A community achieves its land usage goals through a three-phase process. Development of a master plan for the jurisdiction. Administration of the plan by a municipal, county, or regional planning board or commission. Implementation of the plan through public control of zoning, building codes, permits, and other measures. Municipal, county, and regional authorities develop comprehensive land use plans for a particular community with the input of property owners. A planning board manages the master plan and enforces it by exercising its power to establish zones, control building permits, and create building codes. As we discussed earlier in this chapter, in addition to public land use planning and control, some private entities, such as subdivision associations, can impose additional standards of land use on owners. The master plan. Public land use planning incorporates long-term usage strategies and growth policies in a land use plan, or master plan. In many states, the process of land use planning begins when the state legislature enacts laws requiring all counties and municipalities to adopt a land use plan. The land use plan must not only reflect the needs of the local area, but also conform to state and federal environmental laws and the plans of regional and state planning agencies. The state enforces its planning mandates by giving state agencies the power to approve county and local plans. The master plan therefore fuses state and regional land use laws with local land use objectives that correspond to the municipality's social and economic conditions. The completed plan becomes the overall guideline for creating and enforcing zones, building codes, and development requirements. The primary objectives of a master plan are generally to control and accommodate social and economic growth. Capital budgeting. The master plan also includes a budget for how the municipality will spend its money. It outlines what the community expects to acquire and the time frame for when the acquisitions will take place. For example, if the community plans to develop a water park, it must allocate the money for that project as well as set the date for when the project will start. The master plan. Amount of growth. A master plan sets specific guidelines on how much growth the jurisdiction will allow. While all communities desire a certain degree of growth, too much growth can overwhelm services and infrastructure. To formulate a growth strategy, a plan initially forecasts growth trends and then estimates how well the municipality can keep pace with the growth forecast. The outcome is a policy position that limits building permits and development projects to desired growth parameters. A growth plan considers nature, location, and extent of permitted uses, Availability of sanitation facilities. Adequacy of drainage, waste collection, and potable water systems. Adequacy of utilities companies. Adequacy and patterns of thoroughfares. Housing availability. Conservation of natural resources. Adequacy of recreational facilities. Ability and willingness of the community to absorb new taxes, bond issues, and assessments. The master plan. Growth patterns. In addition to the quantity of growth, a master plan also defines what type of growth will occur, and where. Major considerations are the type of enterprises and developments to allow, residential density and commercial intensity, effects of industrial and commercial land uses on residential and public sectors, that is, where to allow such uses, effect of new developments on traffic patterns and thoroughfares, effects on the environment and environmental quality, effect on natural resources that support the community, code specifications for specific construction projects, accommodating demand. As the master plan sets forth guidelines for how much growth will be allowed, it must also make plans for accommodating expanding or contracting demand for services and infrastructure. The plan must identify facilities requirements for local government, new construction requirements for streets, schools, and social services facilities such as libraries, civic centers, etc. New construction required to provide power, water and sewer services. Master plan development and management plan development. In response to land use objectives, community attitudes, and conclusions drawn from research, the planning personnel formulate their plan. In the course of planning, they analyze population and demographic trends, economic trends, existing land use, existing support facilities, traffic patterns. Plan management. Public land use management takes place within county and municipal planning departments. These departments are responsible for implementing the master plan over the long term, creating rules and restrictions that support plans and policies, enforcing and administering land use regulation on an everyday basis. In most areas, a planning board made up of officials appointed by the government's legislative body handles the planning function. The board oversees the operations of the department's professional planning staff and support personnel. In addition, the board makes recommendations to elected officials concerning land use policy and policy administration. The planning board is responsible for approving site plans and subdivision plans, approving building permits, ruling on zoning issues. Subdivisions. The planning board develops the subdivision regulations. When establishing these regulations, the board will consider the demographics of the area it regulates. Demography is the statistical study of human populations, especially with regard to size, density and distribution. The board members use this information to decide if the community can support the new development project. The board also uses data from census tracts to help establish the needs for housing and services in an area. Census tracts are small, relatively permanent statistical subdivisions of a county. Census tracts are delineated for most metropolitan areas and other densely populated counties by local census statistical areas committees following Census Bureau guidelines. Physical surveys are also essential in the planning. Counties must coordinate the plans of smaller municipalities to ensure orderly growth, including providing for the infrastructure of the communities, water usage, utilities, schools, roads, medical services and police and fire support. All these plans are put into effect through zoning ordinances. The addition of new subdivisions in an area will force communities to increase their services, due to the added population. When proposing new development, these new demands must be taken into account. Sometimes developers are asked to pay fees to municipalities to help defray the cost of at least some of the added services. Subdivisions. As we mentioned on the previous screen, Most communities have subdivision regulations that were determined by the planning board. These regulations usually cover the following issues: location, grading, surfacing, alignment and widths of streets and highways, sewer and water main installation, minimum dimensions of property lots, setback lines for structures, areas reserved for public use, such as parks and schools, public utility easements, development costs. Several costs are associated with the site development of a subdivision. These costs include the preparation of the land, the installation of utilities and the building of streets and sidewalks. The developer is responsible for the cost of many of these items, although the planning board through its regulations may agree that the municipality can help defray these costs. Other costs involved with the development effort include application fees, engineering fees, site investigation fees, hookup fees. The developer also may be responsible for impact fees to help cover the costs of the new infrastructure. Check your understanding. Print this screen, answer the questions and then advance to the next screen to see the answers. 1. What is the challenge of a master plan? 2. What do planning personnel analyze when formulating the master plan? 3. What do subdivision regulations usually cover? 4. Who is responsible for the costs associated with a subdivision development? Check your understanding. Answers: 1. What is the challenge of a master plan? To incorporate long-term usage strategies and growth policies, reflecting the needs of the local area, and also conforming to state and federal environmental laws and the plans of regional and state planning agencies. 2. What do planning personnel analyze when formulating the master plan? In the course of planning, they analyze population and demographic trends, economic trends, existing land use, existing support facilities, traffic patterns. 3. What do subdivision regulations usually cover? Location, grading, surfacing, alignment and widths of streets and highways, sewer and water main installation, minimum dimensions of property lots, setback lines for structures, areas reserved for public use, such as parks and schools, public utility easements. 4. Who is responsible for the costs associated with a subdivision development? The developer is responsible for the cost of many of these items, although the planning board through its regulations may agree that the municipality can help defray these costs. Zoning actions. At times, the planning board may recommend that the local authorities consider zoning actions other than those we have described. These actions include moratoriums, variances, special use permits and rezoning. Moratorium. A moratorium is a temporary suspension of the development of a property. For example, issuance of building permits could be suspended while a government agency studies the zoning controls currently in place for a particular project. Sometimes a moratorium is put in place when a municipality does not have the services it needs for the proposed development. In such a case, the municipality would have time to make the services available, and then the moratorium could be lifted to allow the development project to proceed. A moratorium is sometimes known as a zoning freeze. Spot zoning. Spot zoning occurs when a small area of land or section in an existing neighborhood is singled out and placed in a different zone from that of neighboring property. For example, a park or school might be allowed in a strictly residential area if it serves a useful purpose to the neighborhood residents. Another example of an acceptable spot zone might be a small grocery or convenience store that would provide easy access to the surrounding residential area. In some areas of the country, the courts have found spot zoning illegal on the ground that it is incompatible with the existing land use zoning plan or in an overall zoning scheme for the community. Spot zoning is illegal in New York State. Other planning-related actions for requirements. In addition to local regulation, subdivisions must meet FHA requirements to qualify for FHA financing insurance. The FHA sets standards similar to local ordinances to ensure an adequate level of construction quality, aesthetics, and infrastructure services. Plat Approval. The developer submits a plat of subdivision containing surveyed plat maps and comprehensive building specifications. The plat, at a minimum, shows that the plan complies with local zoning and building ordinances. The size and shape of the lots will determine the population density the subdivision can accommodate without overcrowding the area. The plat will also include a legal description and any easements that run with the property. The plat will show the street and traffic patterns and identify all the cul-de-sacs. The project can commence only after the relevant authority has approved the plat. Planned unit development. A planned unit development is a housing concept that produces a high density of residential housing units, a maximum use of open spaces, and greater development flexibility, which results in lower-priced homes and minimum maintenance costs. The PUD concept enables a developer to get a higher density than is allowed with the underlying zoning. In PUDs, the buildings are normally clustered together, leaving more green space available for parks and recreation. PUDs are often specifically provided for in zoning ordinances or are listed as conditional permitted use. Site plan and review. The local planning boards have the right to review site plans in New York State. This review gives the board the opportunity to assess the impact the plan will have on the community. The plan must have enough information for the board and other government agencies involved in the review to determine if the plan complies with zoning ordinance requirements. The plan must address the land's topography, that is, its physical features and contours. This includes the soil types, location of water bodies, and location of various types of vegetation such as trees. The plan must include the utilities that are currently available as well as those that are proposed to be implemented as part of the plan. It must also include information about easements, surrounding zoning, open spaces, street and sidewalk configurations, environmental issues, types of proposed buildings and the marketing plan. The site plan also includes a survey of the property itself, giving the dimensions and showing the property boundaries. Zoning appeals. A county or local board, usually called the Zoning Board of Adjustment or Zoning Appeals Board, administers zoning ordinances. The board rules on interpretations of zoning ordinances as they apply to specific land use cases presented by property owners in the jurisdiction. In effect, the zoning board is a court of appeals for owners and developers who desire to use land in a manner that is not entirely consistent with existing ordinances. The board conducts hearings of specific cases and renders official decisions regarding the land use based on evidence presented. A zoning board generally deals with such issues and appeals as non-conforming use, variance, special exception or conditional use permit, zoning amendment. If the board rejects an appeal, the landowner may appeal the ruling by petitioning the New York Supreme Court through an Article 78 proceeding. You may recall from our discussion in an earlier chapter, an Article 78 proceeding is an appeal that is initiated because of a ruling made by a government agency. Non-conforming use. A non-conforming use is one that clearly differs from current zoning. Usually, non-conforming uses result when a zoning change leaves existing properties in violation of the new ordinance. This type of non-conforming use is a legal non-conforming use. A board usually treats this kind of situation by allowing it to continue under one of these circumstances indefinitely, until the structures are torn down, only while the same use continues, until the property is sold. For instance, a motel is situated in a residential area that no longer allows commercial activity. The zoning board rules that the motel may continue to operate until it is sold, destroyed, or used for any other commercial purpose. An illegal non-conforming use is one that conflicts with ordinances that were in place before the use commenced. For instance, if the motel in the previous example is sold, and the new owner continues to operate the property as a motel, the motel is now an illegal, non-conforming use. Other zoning mechanisms. Special use permit. A special use permit or exception grant authorizes a use that is not consistent with the zoning ordinance in a literal sense, yet is clearly beneficial or essential to the public welfare and does not materially impair other uses in the zone. A possible example is an old house in a residential zone adjacent to a retail zone. The zoning board might grant a special exception to a local group that proposes to renovate the house and convert it to a local museum, which is a retail use, since the community stands to benefit from the museum. Amendment or rezoning. A current or potential property owner may petition the zoning board for an outright change in the zoning of a particular property. For example, a property zoned for agricultural use has been idle for years. A major employer desires to develop the property for a local distribution facility, which would create numerous jobs, and petitions for an amendment. The board changes the zoning from agricultural to light industrial to permit the development. Since a change in zoning can have significant economic and social impact, an appeal for an amendment is a difficult process that often involves public hearings. Variances. A zoning variance allows a use that differs from the applicable ordinance for a variety of justifiable reasons. If a landowner wants to apply for a variance, he or she must apply to the local zoning board of appeals. New York allows two types of variances. Use variance. Area variance. Use variance. A use variance gives permission to use the land for a purpose not allowed by the current zoning. A use variance addresses all of the following points. The owner is deprived of all economic use or benefit. The hardship is unique and not universal to the neighborhood or area. The use will not change the essential character of the area. The alleged hardship is not self-created. When deciding on granting a use variance, the Board of Appeals will grant the minimum variance needed to address the problem. An example of a use variance is a homeowner applying and receiving a variance to construct a two-family home in an area that allows only single-family residences. Variances. Area variance. An area variance permits an applicant to vary one or more of the dimensional or physical requirements of the applicable zoning law, code or ordinance in connection with some proposed construction. Bulk area requirements include such issues as front, side and rear yard setbacks, lot width, lot area, building height, amount of off-street parking and maximum percentage of building coverage. An area variance considers the benefits to the individual landowner against the possible harm to the health, safety, and welfare of the neighborhood. When considering an application for an area variance, the Board of Appeals looks at any undesirable change or harm to the nearby properties that would result if the variance is granted. If the benefit the applicant is seeking can be achieved in another feasible way. If the requested variance is substantial. If granting the variance would have an adverse effect or impact on the physical or environmental conditions in the neighborhood or district. If the difficulty was self-created, which in and of itself would not preclude granting the variance. An example of an area variance would be an owner who receives a variance to build a home on a 10,000 square foot lot, when the zoning ordinance currently states that all one-family homes must be built on lots that are at least 10,500 square feet. Local enforcement. Land use regulations are enforced by the following local entities. Building departments, which employ building inspectors, code enforcement officers and other personnel to oversee adherence to building codes. Professionals who specialize in needed areas. These professionals include civil engineers who give topographical descriptions of land and compose roadway maps, environmental engineers who evaluate compliance with important environmental issues, surveyors who draw up property boundaries for parcels proposed for development projects, land use planners who guide the implementation of the master plan, Board of Health which oversees issues regarding drinking water safety and sanitation requirements, local courts which oversee the decisions made regarding land use and who most often uphold the decisions made by the municipalities. Check your understanding. Print this screen. Answer the questions and then advance to the next screen to see the answers. 1. What is a moratorium? 2. What is a planned unit development? 3. Give an example of a legal and illegal non-conforming use. 4. What is the difference between a use variance and an area variance? Check your understanding. Answers 1. What is a moratorium? A moratorium is a temporary suspension of the development of a property. 2. What is a planned unit development? A planned unit development is a housing concept that produces a high density of residential housing units, a maximum use of open spaces and greater development flexibility, which results in lower-priced homes and minimum maintenance costs. 3. Give an example of a legal and illegal non-conforming use. Legal: a motel is situated in a residential area that no longer allows commercial activity. The zoning board rules that the motel may continue to operate until it is sold, destroyed, or used for any other commercial purpose. Illegal: that same motel is sold, and the new owner continues to operate the property as a motel. 4. What is the difference between a use variance and an area variance? A use variance gives permission to use the land for a purpose not allowed by the current zoning. An area variance permits the variance of one or more of the dimensional or physical requirements of the applicable zoning law, code, or ordinance in connection with some proposed construction. Summary review. This concludes Chapter 17. Below is a summary which you can review before taking your quiz. Individual owners have the right to put private controls on their own property. The controls could take the form of individual deed restrictions or private subdivision regulations that affect the entire subdivision. Individual deed restrictions place limits on how the property may be used. Restrictive covenants are limitations placed on the use of land by the developer of a residential subdivision. Restrictions must be reasonable, and they must benefit all property owners alike. The property owners can enforce the covenants by taking a court action known as an injunction. An injunction prevents the owner or owners from using a property in a way that is contrary to the recorded restrictions. The doctrine of laches states that if a property owner is lax in protecting his or her rights, the property owner may lose those rights. New York State Environmental Quality Review Act requires all state and local government agencies to assess the environmental significance of all actions they have discretion to approve, fund or directly undertake. If an action is determined to have possible significant adverse environmental impacts, an environmental impact statement is required. The agency that oversees a project and makes the final decisions is called the lead agency. Summary review. Summary police power gives a government entity the ability to fulfill its responsibility to provide for the health, safety, and welfare of the public. The Interstate Land Sales Full Disclosure Act is a federal law that regulates the interstate sale of unimproved lots. The purpose of this act is to prevent fraud in marketing land that can be sold sight unseen. Developers must file a statement of record with HUD before they can offer any unimproved lots for sale by telephone or through the mail. Developers must also provide a buyer or lessee with a printed property report, which gives specific information about the property, before the buyer or lessee signs a purchase contract or lease. New York State Article 9 requires a subdivider to make a filing with the New York State Department of State before offering to sell or lease subdivided vacant lands to New York State residents on an installment plan. Eminent domain allows a government entity to purchase a fee, leasehold, or easement interest in privately owned real property for the public good and for public use, regardless of the owner's desire to sell or otherwise transfer any interest. In exchange for the interest, the government must pay the owner just compensation. A taking refers to the taking clause of the Fifth Amendment, which says, in part, that private property cannot be taken for public use without just compensation. Summary review. Summary building codes allow the county and municipality to protect the public against the hazards of unregulated construction. Building codes establish standards for virtually every aspect of a construction project. New York requires that an owner, contractor, or developer obtain a building permit, which gives permission for the construction or renovation of a building or improvement. A building permit must be obtained before the project starts. The vehicle for zoning a city or county is the zoning ordinance. The intent of zoning ordinances is to specify land usage for every parcel within the jurisdiction. One of the primary applications of zoning power is the separation of residential properties from commercial and industrial uses. Residential zoning restricts land use to private, non-commercial dwellings. Commercial zones include restaurants, stores, hotels, motels, service businesses and the like. Commercial zoning controls the location of office and retail land usage. Industrial zones are made up of manufacturing companies and warehouses. Vacant land has no buildings or improvements. Agricultural zoning restricts land used to farming, ranching, and other agricultural enterprises. Public open space is space that is not developed for a particular residential, commercial, industrial or institutional use. Parklands are areas of recreation for the public. Recreational areas include parks, shorelines, public fishing access areas, trails and access to waterways. Institutional areas include hospitals, prisons, courthouses, colleges and public schools. Summary review. Summary cluster zoning is a type of zoning in which density is determined for an entire area, rather than on a lot-by-lot basis. Transfer of development rights refers to a method for protecting land by transferring the rights to develop from one area and giving them to another. Public land use planning incorporates long-term usage strategies and growth policies in a land use plan, or master plan. A moratorium is a temporary suspension of the development of a property. Spot zoning occurs when a small area of land or section in an existing neighborhood is singled out and placed in a different zone from that of neighboring property. A developer must submit a plat of subdivision containing surveyed plat maps and comprehensive building specifications. The project can commence only after the relevant authority has approved the plat. A county or local board administers zoning ordinances. The board rules on interpretations of zoning ordinances as they apply to specific land use cases presented by property owners in the jurisdiction. If the board rejects an appeal, the landowner may appeal the ruling by petitioning the New York Supreme Court through an Article 78 proceeding. Summary review. Summary: a non-conforming use is one that clearly differs from current zoning. A special use permit or exception grant authorizes a use that is not consistent with the zoning ordinance in a literal sense, yet is clearly beneficial or essential to the public welfare and does not materially impair other uses in the zone. A current or potential property owner may petition the zoning board for an outright change in the zoning of a particular property, known as a rezoning. A zoning variance allows a use that differs from the applicable ordinance for a variety of justifiable reasons. A use variance gives permission to use the land for a purpose not allowed by the current zoning. An area variance permits an applicant to vary one or more of the dimensional or physical requirements of the applicable zoning law, code or ordinance in connection with some proposed construction. Click here if you would like to open this summary as a PDF, which you can then print or save to your device. Chapter 17 Summary. Chapter Conclusion. In this chapter, we have discussed private land use controls, including deed restrictions, public land use controls, including police power, taxation, building codes and eminent domain, zoning classifications, the role of a planning board, variances. In the next chapter we'll discuss construction issues. Now it's time for your chapter quiz. Good luck! 1 of 20 How are covenants enforced? By injunction. 2 of 20 Which form of land use control places limits on how a property can be used? Deed restrictions. 3 of 20 In addition to government entities, which of these organizations may be able to condemn property under the power of eminent domain? Public utilities. 4 of 20 If an action is determined to have possible significant adverse environmental impacts, an is required. Environmental Impact Statement 5 of 20 in most jurisdictions. Who manages the master plan? The Planning Board. 6 of 20 The Interstate Land Sales Full Disclosure Act is administered by HUD. 7 of 20 allows a government entity to take privately owned land from the owner for a fee for public use and public good. Eminent Domain. 8 of 20 What can Sarah's neighbors do if she violates restrictive covenants and installs a swimming pool on her property? File for an injunction. 9 of 20 What is the purpose of restrictive covenants in a subdivision? To preserve and protect the quality of land in subdivisions and to maximize land values. 10 of 20 What is the best definition of a master plan? A fusion of land use laws and local land use objectives and strategies. 11 of 20 What are the primary objectives of a land use plan? To control, accommodate social and economic growth. 12 of 20 New York's requires all state and local government agencies to assess the environmental significance of all actions they have discretion to approve, fund or directly undertake. State Environmental Quality Review Act. 13 of 20 Which of the following is not a common type of zone classification? Military. 14 of 20 actions listed in the SEQR regulations that have already been determined to not have an adverse impact on the environment are called Type 2 actions. 15 of 20 in New York, liens take priority over any other liens. Property tax. 16 of 20 What happens to a person's property if he or she dies with no will and no heirs? The state will use the power of SEQR to claim the property. 17 of 20 Which of the following would not be included in an environmental impact statement? The cost of the project. 18 of 20 If a municipality exerts its power of eminent domain against a certain property owner, what happens? The owner must sell the property or grant an easement to the municipality for just compensation. 19 of 20 What do we call programs that encourage a shift in development away from environmentally sensitive areas to more appropriate areas? Transfer of development rights. 20 of 20 What is a housing concept that produces a high density of residential housing units, a maximum use of open spaces, and greater development flexibility? A planned unit development.